Hello. I'll begin my remarks with a personal story of how I met Reich as well. I had sent him a copy of my 2016 essay, The New Public, which was a riff on the new property. And Reich got in contact with me, invited me over to his house in San Francisco for lunch. And we spent a long afternoon together talking. And he was so generous with me. He gave me permission to ask him anything I wanted to ask, because I was working on a book, and the essay was going to be a chapter in the book. So he said I could ask him anything I wanted, and he also gave me permission to be critical of his scholarship. And for that, I was so grateful. The New Public is it's about Reich's biography and scholarship through the history of the automobile. And the book that I ended up writing is called Policing the Open Road. And I relied on Reich's scholarship to talk about the relationship between administrative law and criminal procedure, which not many people had done before. And I'll mention a little bit more about that towards the end of my talk. So I want to begin by telling you about this compilation of law review articles that David Kennedy and William Fisher put together in 2006 called the Canon of American Legal Thought. And to make this compilation, they consulted their colleagues in legal academia, and they asked them for scholarship that met their standard of having been moments of methodological innovation, which have left lasting traces in the legal reasoning practices of American lawyers and judges. Some people have noticed a Harvard bent to their compilation. Judge Calabresi, your co-authored piece, One View of the Cathedral, made it into the canon. The editors also explained that some innovations that once seemed crucial but were not sustained were understandably no longer on the tips of tongues. We were sorry, for example, to find little mention of Charles Reich's 1964 essay, The New Property, among colleagues today. So while Harvard law professors may not have talked about the new property much by the early 2000s, historians have rediscovered it and Reich's other writings in recent years. And Karen Taney's book, States of Dependency, is a great example. My book, I told you, has a chapter about Reich's scholarship and biography. Another is I brought with me historian Sarah Igo's recently published book, The Known Citizen, which is a history of privacy in America. And Sarah Igo is actually not a legal historian, she's not a lawyer, but she's an intellectual historian. And so today I want to talk about Igo's discussion of Reich and the history of privacy, which follows naturally from your talk. And I want to talk about this discussion of Reich in her book as a way to talk about the relationship between historical and legal studies. Basically, what can legal scholars learn from historians, and what can historians learn from legal scholarship? And I'll begin with the first part about what legal scholars can learn from historians by providing a summary of Igo's main arguments. So according to Igo, privacy is not so much a thing that we have or have lost. It would be incorrect, according to her, to talk about the absence of privacy or that we've lost our privacy. And instead, she says it's a discourse about the costs and benefits of modern society. And she calls this privacy talk. So to put it in another way, whenever Americans debated the modern state, they were talking about privacy. And each chapter of her book illustrates this insight through select topics from the 19th century, late 19th century to the present. And each chapter highlights the paradoxes of living in what she calls a knowing society that seeks to govern and provide for its members by making them more legible. So one of my favorite examples of privacy talk in this book is the chapter on Social Security numbers. The project of setting up a system for keeping track of every individual paying into the program, linking each Social Security contribution to just one person, maintaining a record of each person's employment history, changes of address, age, and more had huge privacy implications. Employees were worried about how their employers would use their personal information. African American leaders were angry that the Social Security application form had a racial designation. Female workers who had falsified their age or marital status so that they could get a job in the first place, they were concerned that their employers would find out and fire them. And if they had said that they were younger than they were, which was almost every case because younger women were able to get jobs more easily, then they couldn't start getting retirement benefits until many years after they actually retired. Labor union members feared that information about a worker's previous position, along with a clue to union affiliation, might become available to a prospective boss. So these were some of the privacy concerns when the Social Security program was just getting rolled out. And today, Social Security numbers are connected to much more information about us. They facilitate the distribution of welfare, healthcare, credit, retirement benefits, and more, but we disclose a lot of our personal private information in exchange for those benefits. So by recasting privacy as a discourse filled with tensions and trade-offs, the known citizen offers a corrective to contemporary debates that envision a giant ledger where privacy is slipping ever more swiftly into the deficit column. A couple of chapters later, Igoe discusses new privacy concerns with the welfare state in the 1960s when Reich and a few others were raising awareness about how welfare regulations and enforcement, like the midnight raids that we learned about earlier this morning, were undermining recipients' dignity, personal liberty, and privacy. In Igoe's perspective, Reich's scholarship reveals how privacy talk could challenge the harms of class and potentially enlarge poor people's citizenship claims. And the inspiration for this radical vision of poor people's rights was the 1965 case Griswold versus Connecticut, which I think everybody in this room knows established a constitutional right to privacy for the very first time. According to Igoe, Griswold allowed Americans to imagine more robust applications of the right to be let alone. But there were a few things about the Griswold decision that perplexed Igoe. In her telling, the court was a latecomer to the decades-long privacy talk, and contraception wasn't even controversial for many Americans at the time. Many married women did have access to contraceptives, so Griswold addressed an issue that no one at the time associated with privacy as a privacy issue. So for Igoe, it seemed odd, even accidental, that the right to privacy made its debut in a reproductive rights case. And because the issue in Griswold was immaterial to larger privacy debates about medical records, people snooping and wiretapping, she argues that the decision ultimately narrowed the scope of the constitutional right to privacy. The radical vision didn't materialize, and Griswold ultimately didn't answer larger questions about whether Americans would tolerate intrusions into a person's private personal life in exchange for the benefits of fuller citizenship. And here's where I think a legal scholar can provide an explanation to the historians. There's an alternative legal history of the right to privacy. It doesn't at all undermine Igoe's account, but it does provide a different perspective and answer some of Igoe's lingering questions. A longer historical view of the right to privacy starting long before 1965 when Griswold was decided casts a different light on the significance and meaning of Griswold. The demise of an expansive constitutional right to privacy lies not in the fact that Griswold was its standard bearer, but it had to do with the conditions of modern society. And one good starting point for this alternative legal history is Lochner v. New York. And this is a familiar story to a lot of you here in the audience. So in 1905, the Supreme Court invalidated a state law limiting bakers' working hours on the ground that it interferes with the right of contract between the employer and employees. Rejecting justifications for the law as a health measure, the court described the state as meddling with, quote, a private business. The court reversed course in the late 1930s, and since then, courts have treated economic regulations as presumptively constitutional. With judicial blessing, local and state governments use their broad police power to govern for the public's health, safety, and morals, and the process helped to build the modern regulatory state. A generation after the court's jurisprudential switch, even progressive legal scholars were beginning to question whether the public interest state had grown so much as to threaten individual freedom and dignity. And this is where we get to Reich. In 1964, he published The New Property about the dangers of Americans' dependence on the administrative state for much of their livelihood, which we talked about all day. In fact, his writings in the 1960s all raised the question, what might be the limits on state power when private property, like owning a private business in Lochner, was no longer served its traditional protective function? Reich's own answer that Ray mentioned was to draw a new zone of privacy, to carry on the work that private property once did but can no longer do. The following year, in 1965, the Supreme Court provided a similar answer in Griswold. According to the opinion, forbidding married couples from using contraceptives had a maximum destructive impact on the marital relationship, a bond that fell within the, quote, zone of privacy, the very same phrase that Reich had used in The New Property. So Igo's right that Griswold largely served a symbolic purpose of upholding marital intimacy. But Griswold was also a long-awaited answer to an important question about the limits of the knowing state. The invocation of privacy makes more sense in this larger context. The Connecticut birth control law fell reliably under the state's authority to regulate for the maintenance of public health and morals. And in an era when private property rights could no longer be invoked to overturn a health law, as in Lochner, the court tried out a fundamental right to privacy. So we see the shift from private property to privacy in constitutional law. The justices didn't have to choose a challenge to a contraceptive ban for its landmark privacy decision. And in fact, the court again turned to privacy just 2 years later in a case involving a warrantless wiretap. Katz versus United States, like Griswold, forged new ground when it declared that the Fourth Amendment protected an individual's reasonable expectation of privacy. Up until then, courts had ruled that Fourth Amendment violations required physical trespass onto a person's private property. And the problem was that wiretaps allowed the government to eavesdrop without setting foot into someone's house. In Katz, the defendant wasn't even in his home. Federal agents had wiretapped a public telephone booth that they knew Katz would use. To protect private conversations held even in public, the court held that the Fourth Amendment protected people, not places. Their reasonable expectations of privacy, that is. So Griswold and Katz might not have been obvious choices for constitutional landmark status, but the facts of these cases made it easier for the Supreme Court. In both cases, the government had invaded a space that could be likened to a house, a private property, the preeminent private sphere in the Anglo-American legal tradition. Justice Douglas, who authored the Griswold opinion, enshrined the sacred precincts of marital bedrooms. Justice Stewart's opinion in Katz insisted that the Fourth Amendment guarantee did not vanish when the search in question is transferred from the setting of a home, an office, or a hotel room to that of a telephone booth. So in a string of analogies, Stewart associated public telephone booths with the ultimate symbol of the private sphere. Tethering the right to privacy to their home had two important consequences. First, it wouldn't be easy to extend Griswold or Katz to cases where the connection to the home wasn't as clear. As crim pro professors have observed, reasonable expectations of privacy turned on how significantly they overlapped with the physical home. And among the reasons why Roe's, and there were lots of reasons why Roe's right to abortion proved much more controversial than Griswold's right to birth control. But one reason was that the analogy to a home in Roe was much more tenuous. The court framed it as a woman and her responsible physician in consultation. This doesn't really conjure up images of a home, and other images seem more apt to those who opposed abortion. Justice Rehnquist argued in his dissent that a transaction resulting in an operation is not private in the ordinary usage of that word. So ultimately, the utility of the constitutional right to privacy was limited where the home would be difficult to evoke for the myriad technologies and activities that were regulated in the modern world, the very modernity that inspired all the privacy talk in The Known Citizen. There's another reason for privacy rights' limited utility, and this should be a familiar reason for law professors. When the court recognized a right to contraceptives, it crafted that right as a fundamental substantive right, that is, a right to be free from government intrusion. Like the right to contract in Lochner, substantive rights prohibit the government from regulating for the public's interests, which would be untenable in a modern society that depends on government regulation. So many privacy rights today are procedural in nature, like the Fourth Amendment. Katz didn't ban the government from electronic eavesdropping. Rather, it required a warrant, a procedural protection, to use a wiretap because flatly prohibiting enforcement mechanisms as privacy violations would hinder the government's ability to govern. And I make this argument in my book through the story of Reich's life. In 1966, Reich wrote an article called Police Questioning of Law-Abiding Citizens, which described the immense discretionary power that police officers wielded in their enforcement of traffic laws. And in the article, Reich related his own numerous encounters with the police in his car. And these car stops were about more than the annoyances of getting pulled over one too many times. They were also about the invasions to his privacy. As a closeted gay man, at a time when sodomy was a crime in all states but one, Reich went for long drives to escape the burdens of keeping his secret. So when the police stopped him in his car and questioned his whereabouts, what's your name, where are you coming from, where you're going, they were prying into the most intimate parts of his personal life. So to protect citizen drivers on the road from the police, Reich proposed a right to privacy in public. And in public referred to the public sphere of the automobile and the road, where the government's interest in regulating automobility justified volumes of traffic laws and a great deal of discretionary policing. And as a legal basis for this right to privacy in public, Reich cited Griswold. The personal nature of Reich's article makes it undeniable that he sought to extend the protective shield surrounding married couples to himself, a gay man. The interesting thing is that Reich never questioned traffic laws and the need to enforce them. And in fact, when I talked to him, he said, we need more enforcement against those crazy drivers. So he never questioned traffic law enforcement and the policing that was required to enforce them. And the Griswold-like substantive right to privacy would have undermined that enforcement regime. So as a result, when describing how privacy in public would work in practice, Reich ended up listing detailed rules regulating police conduct, procedural rights in other words, not like the Griswold fundamental substantive approach. So I go into the chapter on Griswold with the observation that neither Griswold's zones of privacy nor the rulings that followed it could resolve the case's most generative questions. But in fact, Griswold's substantive approach would never have been able to resolve modern society's privacy questions. And not surprisingly, Igo's book concludes with a list of laws like the Video Privacy Protection Act, the Driver's Privacy Protection Act, and the Children's Online Privacy Protection Act. When the blunt tool of constitutional law couldn't take account of both the benefits and dangers of living in a knowing society, Americans relied on the flexibility of statutes to protect at least some aspects of their privacy. So the angst that we have today about the challenge of defining the right to privacy in a digital world is, in a sense, Reich's angst about the tensions between his progressive inheritance and his growing unease about the modern public interest welfare state. In other words, this is all privacy talk.